Hello everyone. So welcome to this video. In this video, we are starting our video lecture on Specific Relief Act 1963. This is a continuation of video from the Contracts Act which we discussed on this channel. Firstly, I want to explain you that what is an importance of covering specific relief act. Specific relief act is a very important legislation in terms of, firstly, it's a very complex legislation. A lot of people find it very difficult to understand it properly. Even practicing lawyers find it difficult to understand because of its complexity. Specific relief act in terms is not a standalone legislation. A lot of concepts of contract acts will be involved, property law will be involved, civil procedure will also be involved. That's why it's very important to dissect each and every section बहुत अच्छे से so that everyone can understand. And also I want to state the fact that Specific Relief Act is very important act because of, firstly, contract drafting, contract negotiation, or whatever it is. Everything in this world is working on contracts, as you already know. We discussed in our contract lectures as well. Contract Act gives you what are the rights and what are the damages, what you can claim. But what the Specific Relief Act give to all of you is, through contracts you have an opportunity. You know what are your rights, you know what are the damages you can claim. But SRA is a mechanism. SRA, Specific Relief Act, you can understand from the wording itself what it is. It is about how to enforce those rights. What are those rights? Through whatever contract you have entered into, there are certain rights which you have acquired through that contract. So it is important that you understand this legislation properly. Also, on the special request, I will be using English as a medium of language. I will be communicating both in Hindi and English because a lot of viewers are not able to understand proper English. So you can also use subtitles as well, ताकि सबको अच्छे से समझ में आए and we can make it a very comprehensive video. ठीक है, so let's start with our video lecture. On सबसे पहले you need to understand what are the core principles which govern the SRA, Specific Relief Act. I am using this SRA as a short form for Specific Relief Act. Firstly, from this handshake movement, what you can understand is that the contracts are based upon mutual promises. This will initially be an introductory video and then subsequently we will move forward with the sections as well. This will be a series of lectures. So understand this as handshake movement, what it is. Handshake movement shows that there are contracts which are based upon mutual performance. This is A, this is B. This could be for some property transaction that A has entered into contract with B. A is a real estate builder, like he's a contractor. Alright, and B, his client. B client has given A some task of building certain hotels. And A later on refuses that I won't be able to do it for XYZ reason. Should in the commercial transaction, should one party be allowed to go away? क्या हम ऐसी ट्रांजेक्शन में अलाउ कर सकते हैं कि ए विल बी लाइक कि अरे मेरे से नहीं हो रहा बिकॉज ऑफ एनी XYZ रीजन, आई कांट डू इट फॉर दिस, सो आर कॉन्ट्रैक्ट इज नाउ रिसाइंडेड, द कॉन्ट्रैक्ट इज टर्मिनेटेड. इससे क्या होगा कि दिस क्लाइंट विल फेस हार्डशिप्स. क्योंकि वाई? बिकॉज ऑल हिज बिजनेस इज बेस्ड अपॉन दैट पर्टिकुलर होटल्स. प्रॉबेबली उसने बहुत ज़्यादा इन्वेस्टमेंट करा हो उस पर. दे कैन बी अ लॉट ऑफ कमर्शियल रीजन्स, कुड बी बहुत सारे इन्वेस्टमेंट करा है फॉर सो दैट दैट पर्सन कैन बिल्ड दोज होटल्स. दैट पर्सन हैज़ गिवन हिज मनी टू ए एंड दोज फंड्स आर नाउ ब्लॉक्ड. ही कुड हैव इन्वेस्टेड वो सारे फंड्स जो उसके पास थे. प्रॉबेबली बी ने ए को 50 लाख रुपीज़ दिए थे फॉर दिस होटल्स फॉर द इनिशियल अमाउंट. ठीक है, एंड वो 50 लाख ही कुड हैव, दैट पर्सन कुड हैव यूज्ड इट समवेयर एल्स. सो फॉर द कमर्शियल certainty, there is always requirement of commercial certainty. Because of that we have this. Because now we can go to court and we can tell to court that this person has not been able to fulfill whatever the contractual obligation was, and it is causing me hardship now, and because of some frivolous reason. Because contracts cannot be terminated. In the contract act, what we studied, there is a clause of damages in a contract. Damages is always there. But is damages, one thing which you need to understand is money able to provide relief for everything? Is money an adequate remedy? That is a question which is an important question which you need to ask when you are dealing with SRA. No, obviously. Why? Because money is not the answer for everything. There are some specific things which, because if two parties have entered into any kind of commercial arrangement, there is always a good faith is involved. Even though this party, now this in this case, A tells to B that I will pay you this 50 lakh or also the damages as well. Will it be able to make a commercial sense for B? Because probably this damages will also not be able to recover whatever hardships B has faced. B had certain dream in his mind that he will open this business, he will have these hotels. That's why money is not the answer, and B should be given an opportunity to approach the court and should be able to enforce the contract. So what the SRA do? SRA is used for some of the SRA. What the SRA is for? If you read the Bare Act and check the SRA provisions only, you will find that SRA as the mechanism is used for recovery of possession of property, specific performance of contracts, specific performance. It's not standalone only based on specific performance of contracts. I had given you this example of specific performance of contract, like the one initial example I've given you because of contract. Because contract is easy to understand. If you have read the property law as well, you would know under TPA Act that we will cover under Transfer of Property Act. If you have studied, then it's well and good. Firstly, you need to understand for the possession of property also the specific relief act is used. Specific relief act in terms of is not creating any rights. It's basically trying to provide the remedy. It's trying to enforce those particular contracts which the parties have entered into. The specific relief act can also be used for rectification purposes, rectification and cancellation of instruments. It can be used for rescission of contracts. You must have a lot of doubts as to what I'm stating, as to understanding as well. But you will understand as we move forward with our videos, declaratory decrees, and for injunction purposes as well. These are some of the scenarios in which this specific relief act is used. Firstly, understand this part about what are the core principles. As I told you, these are the specific circumstances. I have slides as well which explain it, the overview as well. But let's try to understand that what are the core principles. Firstly, whatever parties must perform the terms they have undertaken to perform. The basic principle of performance, as the principle behind SRA is that what the parties have promised themselves, they will be doing that particular thing. But one thing which is important for that is the agreement which the parties have entered into. Like A and B in this case have entered into certain kind of agreement. Those agreements, like in these two cases, what was held in both of these cases, agreement could not be conclusively proved. So obligation could not be ascertained. One thing which you need to understand for enforceability of SRA, specific relief act, is whatever the agreements are entered between the parties, it should be proper agreement. It should be a valid agreement. There should not be an element of ambiguity or vagueness involved. Only then the court can enforce those particular agreements. And there are certain defenses as well. To avoid the specific relief act. Why do you think that we need those defenses? Because SRA, as I told you, are based upon majorly contracts. So there are certain exceptions, like we studied in Contract Act, such as undue influence, fraud, or incapacity. Like because of these reasons, those contracts become void or voidable. If you want to understand more about undue influence fraud, then you should go back to my contract video as well to understand it better. That is because of that, SRA provides some of the relief, but under section 9 of the SRA, there are certain defenses provided under contract. Section 9 provides under SRA certain exceptions, and also under SRA you can use the contract laws defenses as well. The contract law defenses as such, you know that the parties did not have the capacity, there was fraud was involved, misrepresentation was involved. I've mentioned some of the examples. Let's understand the basics of SRA. There's certain chapters which are given under SRA. This has only 8 chapters. SRA as an act has 8 chapters, so it's comparatively shorter chapter. Let's understand the introductory part of this session, this whole act. I will explain you what are the major chapters are of this section, this whole chapter, so that continuous videos which will come in sequence will be easier for you to understand. You understand chapter 1. Chapter 1 is about recovery of possession of property. Firstly, let's also discuss this idiom, which is about ubi just ebi remedium. What is it? Where there is a right, there is a remedy. Basically, what it says that whenever you have any right, as I told you earlier as well, what the contract states, contract is about providing you right, but how will you remedify it? How will you get the remedy? The answer of remedy is SRA, because it is providing you remedy. What it is like, you can also understand in the way that honor your word, which is I really like this whole phrase is honor your word. Honor your word means whatever you have said that you will do, whatever you have promised, now you honor it. To enforce your right to get it honored, to get it done, that is through SRA. So courts basically use this whole principle as such that if you have certain right under the law because of some contract, anybody should not be allowed to just breach it and go away and just pay you damages. If something has been agreed between the parties, there is a commercial senses involved, and it's all practical that the remedy should be provided in terms of whatever has been agreed earlier, it should also be honored. द पार्टीज़ ने जो भी डिसाइड करा था पहले कि हम ये करेंगे, अगर कोई स्पेसिफिक रीज़न नहीं है, स्पेसिफिक रीज़न इन द सेंस लाइक कि बिकॉज ऑफ सर्टन XYZ रीज़न विच फॉर द कोर्ट ऑल्सो साउंड टू बी लॉजिकल, प्रैक्टिकल, विच इज़ इक्विटेबल. अगर कोर्ट को लगता है कि जो दूसरा इंसान है, जैसे हियर इन दिस केस दैट बिल्डर इज़ नॉट बिल्डिंग दोज, that person has to provide certain justification. अगर वो नहीं कर पाता and this party wants it and goes to court to specifically enforce it, तो फिर एक को वो काम करना होगा. That is the whole scenario on which it is based upon. Okay, so let's move on to SRA, the major provision which governs SRA, which you will also read in your saving clause as well. SRA does not confer any right by itself. The purpose of the statute is not to give any right to anyone. What it do is, it rather outlines specific relief measures. Specific relief measures is that if this harm has been done, if this damage has been done, what should be the specific relief measures. So it does not give you compensation. It's not a mechanism to give you compensation. It is a kind of mechanism. It helps you get back your property, your deal, your legal status. Whatever was the legal status, nobody should be allowed to come and just dishonor something and just get away with that. The specific relief measures, let's discuss those specific relief measures which this SRA provides. Firstly, it's about recovery of possession of property. This is the first chapter of SRA. What it states is it provides a provision of relief to those who have been dispossessed of the property. Dispossession of the property. Just I'll give you example. If you understand, there is a this case, this is a very interesting picture which I've taken. Is this just imagine he is James. He's James and he's king of this palace, and he's staying here happily, and he enjoys in his rosy garden. Flowers are there, trees are there, and he's happy. He's staying here for a long time. All right, and these two trespasser on this land, they just come up and says that they come up with a fake deed. All right, and these two people, they tell to Prince James that you get lost from this property. Now we are the ones who will stay on this property. So what the James will do? What the James can do? Do James will be happy with taking just the compensation? He will be like, okay, let's just give me the price of this palace. No, this is not what the James want. James is happy in his palace. He was living here for a long time. That's all. So what we want is he has been dispossessed of his property. Alright, so this basically because James here has the title. There are a lot of scenarios of dispossession of property as well. We will deal with in detail. But just to give an overview about this, he has been dispossessed of his property. So nobody cannot be allowed to grab another's property if that person has title. Even if not the title, just imagine the scenario. There is a landlord and there is a tenant. Tenant has been living here peacefully, and these two people has a rent agreement between them. Even if that land on which tenant is staying belongs to landlord, should landlord be given such powers to throw tenant out of the place at his own will? Should that be allowed? In this case, what the tenant wants that there was a rent agreement between us. You cannot unilaterally come and throw me out of that place because here I have been staying here. So what the tenant will do? Tenant will approach court under SRA. That will the tenant will do. That is the whole scenario. That's something which chapter 1 of this SRA deals with. We'll deal with it very comprehensively in the next video, but let's have the overview. Then about the specific performance of contract. I'm just giving you examples to appreciate what the SRA is about, so that you are more enthusiastic, ताकि आपको अंडरस्टैंडिंग हो कि हम पढ़ क्यों रहे हैं ये एक्ट, क्यों हम लोगों को इसकी ज़रूरत है. अगर सेकेंड वाला पार्ट आता है अबाउट स्पेसिफिक परफॉर्मेंस ऑफ अ कॉन्ट्रैक्ट, जिसका एग्जांपल मैंने पहले भी दिया. I gave you the example in which we were talking about that contractor and that client. Now I'll give you hospital example. Why it is so important to specifically enforce that contract. Mere performance of duties under the contract. Everyone has duties under a contract when they enter into it. It's often important as a contract is generally one in a chain of contracts, and the non-performance of the obligation upsets all. So let's appreciate this with an example. एक example के through मैं आपको बताऊंगी how it happens. Just imagine there is a hospital and there is a supplier of oxygen, and they have a chain of contracts. What I mean is, so they have a contract that they have a contract for the 12-month of period. You will provide us with this oxygen supply, because oxygen is a scarce resource. So बहुत कम suppliers ही provide करते हैं, and there is a commercial agreement between them. And अगर hospital को oxygen नहीं मिला, the life of patients is at stake. Patients को oxygen चाहिए, जिनको oxygen चाहिए, those who are in ICU or something. So this is something. तो hospital वाले अगर oxygen supplier वालों का this contract is breached, supplier बोल रहा है कि no, I can't give you, I will give you compensation for the breach of the contract. Will it be sufficient? हॉस्पिटल वालों के लिए will it be sufficient? So हॉस्पिटल वाले what they want कि there was a contract between them, commercial sense में there was a contract between them. How can you breach it now? Because supply is very important for us. We don't want compensation, we want specific performance, and they can approach the court. So that is why we have this. You understanding? So what the hospital want? They want the supply. They want that supply should be done. They want a specific performance of it. Alright, now next understand about the rectification, cancellation of instrument and rescission of contract. This is also something which is done by specific relief act. Specific relief act is not only limited to the contracts कि specific relief मिल गया, हमें property अपना मिल गया वापस. It's also for ratification as well and cancellation of instruments as well. Why it happens, how it happens, let's have an overview about it. Numerous contracts required to be in writing, some for mere expediency. बहुत सारे contracts are sense. What are those contracts? Contracts are like sale deed. So there are a lot of sale deeds are involved, a lot of instruments of law. Alright. So what you need is those instruments should be in writing. An instrument is a result of negotiation between the parties. We also discussed that how the contract is formed. There is a negotiation between the parties. There is communication. There is acceptance between the parties. Offer, everything we discuss in Contract Act. If you want to understand, you should go back to those videos. Sometimes may not be able to express the true intent of the parties. But क्या होता है कि कई बार there is a mistake in it. Mistake in the sense like I'll give you an example. So your dad has a property deed, and in that there is accidentally plot 21. It's written plot 21 but it is plot 12. Do you think it will create ambiguity? Ambiguity is what? कि अगर ये डीड जो है ये ऐसे ही रही, इवन तो ये डीड प्रॉपरली एग्जीक्यूट हो गई है, प्रॉपरली द रजिस्ट्रेशन इज डन, एवरीथिंग अंडर TPA. TPA is transfer of property act. We will deal with it. If you have dealt with it already then it's good. जस्ट अंडरस्टैंड इतना ईजीली कि ये डीड जो है ये प्रॉपर है, इट्स अ वैलिड डीड. बट इसमें इम्पॉर्टेंट जो है, दिस इज अ मटीरियल टर्म. वी डेल्ट विद व्हाट अ मटीरियल टर्म इज. मटीरियल टर्म इज एन इम्पॉर्टेंट टर्म. Material term, why? Because इसमें plot number, the thing which is important, I call it essence means the heart of the contract. जो एक तरह का दिल है contract का, वो है कि plot number कौन सा है. plot number 21 लिखा हुआ है but it is 12 plot. ठीक है. तो so SRA is a mechanism. Under SRA courts can rectify mistaken document. गलत हुआ है तो you can get it rectified. Or it can also be for cancellation of documents. Why cancellation of documents? If you see, we had dealt with defenses under the contract. What are those defenses? Fraud, undue influence, coercion. Those are some of the scenarios which we had dealt with. If such kind of things are there, then also you can under SRA go and tell the court that it is not expressing the true intention of the parties, and because it is avoidable, so you can get it away with that. You can under SRA as a mechanism you can cancel that particular instrument of law. Contracts are not only instrument of law. There are a lot of other instruments of law like mortgage deed. There are sale deed. There are a lot of things are involved. You will deal and you will be doing your property laws and your further legal education as well. But to understand this, you need to have the understanding कि ये कैसा होता है. Rectification of executed documents, we have dealt with it. Certain documents mistakenly executed required cancellation. So section 5 of SRA ये भी allow कर देता है. Certain contracts have to be rescinded, which is facilitated under section 5 as well, because you want to terminate it. Let's move on to the part about preventive reliefs. Importance of SRA also lies in the fact that it provides us with a preventive relief. What is preventive relief? Prevention basically means to stopping something before it happens. before it happens. That is called as prevention. Like I've taken certain prevention. In the legal sense, you can understand prevention in that. If somebody is doing something, like if A is demolishing B's building. This is a B's building. And B, it's demolishing B. So you cannot only want that A to recover all the damages. We don't want this building to be demolished. अगर बिल्डिंग डिमोलिश हो गई, बिल्डिंग टूट गई, बिखर गई, ब्रेक हो गई, तो बी का ही नुकसान होगा. बी, इट इज़ नॉट लाइक कि ए बोल देगा कि अरे मैं पे कर दूंगा उतना. कैन दैट पर्सन विल बी एबल टू बिल्ड दैट बिल्डिंग इन दैट लेसर अमाउंट ऑफ टाइम? व्हाट द बी वांट्स. कोर्ट बी से क्या मांगेगा? व्हाट इज द रिक्वायरमेंट? व्हाट विल द बी आस्क? बी वांट्स द कोर्ट टू stop this demolition. Stop. That is a prevention which the court wants, which the B wants. That's a prevention. So SRA as a act also provides us with the preventive reliefs as well. If an party threatens breach through act or omission, कुछ करने से या ना करने से, a party is threatening another party for act or omission, तो कोर्ट के पास एक पावर है of injunction, which you will deal with in the later sections. जब इस chapter को हम properly discuss करेंगे, you will understand what the injunction is about. But to give you an example so that you can understand it properly right now, only the introductory part, I'll give you the example of a singer. Courts can enforce negative undertakings in a contract. This is just an example of negative undertaking, positive undertaking, you will understand later. But to give you an example, under chapter 7 you will discuss about preventive reliefs. I'm giving you example. There is a college fest. College का fest था and you hire a singer. There is a singer. Because in college fest you have a singer. When we have prom night or something, singer, you hire a singer. He's like, okay, on this date, like on the date of 12th of October, I will sing on this play at your college, and he says that I'll sing there. This is a positive undertaking that that person will do this thing. And he also, in the contract there is a undertaking which is like he will not sing at any other place. Firstly, understand this is a contract of personal service. This is a contract of personal service. So you cannot enforce it. But what you can enforce is the singer cannot be allowed to sing anywhere else. So you can obtain the court a preventive relief. He will not be allowed to sing anywhere else is something which is a preventive relief which you can claim from the court. Why the personal services are not enforceable, we will deal with it in the later videos. Let's move on to the declaratory relief, which is also provided under SRA. So what are a person may be, I'm so sorry for this. A person may be entitled to some status or may have some right in the property. Someone may be denying it. It's like declaration. What the party wants. Here in this case, if you understand how the declaration works, just take an example of grandfather's house. You have a grandfather's house. All right. In the will, he has written your name that this house will now belong to you. This is my house. But your uncle comes, your relative, who comes and tells that no, he is the real owner. But you know that you are the real owner. To avoid any legal tussle, to avoid this party to go to court and all. What you want here, you don't want any compensation. What you want? You want the court to just declare that you are the owner. You are the owner. That is what you want. This is something which is called as what you want from the court is declaratory decree. Declaratory decree is what you want. Or there can be another examples as well. This is not limited to this. Any sort of civil remedy which you can claim, civil right you have. What kind of civil right you have? Like you are married to someone and other one claims that no, you are not legally married. You can ask the court to declare it. Once the court declares it, it will be acceptable by the society as well. So this is how SRA provides such kind of reliefs. To understand it in detail, a lot of provisions which discuss and a lot of technicalities which are involved as well, but we will step by step deal with everything. Let's move on to the saving clauses. Something which you need to understand about SRA is saving clause. What the saving clause is, if you don't know about it. So saving clause basically protects a particular clause or act from being affected by other acts or sections. So what the saving clause of SRA states is, this act's purpose. Saving clause basically here it's stating the fact that SRA provides you certain remedies, but this is in addition to other reliefs. This basically means that if there is a contract and under this contract you can claim some damages, you can claim compensation. This you can do. The SRA is an addition. SRA is an addition through which you can claim specific performance as well. Specific performance of this contract or whatever we have discussed, the remedies which we have discussed. You can claim these all, but the effect of this will not go away. This will not be deprived. If you read the saving clause, it states that except as otherwise provided here, nothing in this act shall be deemed to deprive any person of any right to relief other than a specific performance which he may have under any contract. This SR is providing you specific relief other than specific relief, because there could be a possibility that the court denies specific relief. There is a possibility court denies specific relief or maybe providing the specific relief. This will be taken as separate from this remedy. This remedy under the contract, whatever, or any other act. Like you have the remedy under CPC, Civil Procedure Code. You can sue a person under some other section of CPC. Here you have not, I'm just assuming you have not studied any other act and all, but just to take into example that remedies are also provided in some other statute. There is a possibility that this remedies can be provided in some other statute, certain other legal provisions. So those legal provisions you can certainly use. If you read this section, so also if you read section 3 of SRA clause B, it also stated that it's not going to affect the operation of the Indian Registration Act 1907, Indian Registration Act. Why it states so? There are certain, if Registration Act requires the registration of certain documents, you still need to get them registered. SRA will not be very helpful if you do not get them registered. What this means is, if you just imagine this scenario, I'll give you one more example to make it clear. You buy a flat, okay? You buy a flat, and that agreement which you had with the broker or the contractor from whom you bought that flat, it is an unregistered agreement. So do you think this unregistered agreement, will you be able to enforce it under SRA? Because Registration Act's provisions will apply, because here what the Registration Act states, such kind of agreements require to be registered. If the seller later on sells this land to someone with proper registration deed, the one who with the proper registration deed, that person will be able to execute it under SRA as well, and the Registration Act provision has also been fulfilled. Can this person who has been ignorant about his right, because वो उस इंसान को खुद ही नहीं पता था कि उसने register नहीं करवाया, under property laws you will understand about Registration Act as well, but to give you a scenario कि कैसे ये सब हो सकता है. Basically what I meant to say by all of this which I said is कि SRA की provision cannot help you with something which is required under mandatorily required under other act, क्योंकि Registration Act के अंडर ये required है कि आपको register करना है, then only to become a valid a valid registered agreement, it will be a valid contract only then. You cannot get it enforced under SRA. Because you have this right. You have not created the right properly. The SRA cannot magically cure every defect. This magically cannot be. The basic property and the registration laws will still stay intact. SRA basically is providing you a remedy. It's not a shortcut act to get enforced your contract or to rectify your mistakes. The proper procedure, how it works, one by one section we will discuss from the next videos. One thing also, the last thing which I want to tell you about is, it is only enforcing civil rights. As I told you, all the remedies, as we have also discussed, all were the civil remedies, and in nature was civil in the nature. It was not penal remedies. What it means is, if someone has assaulted you, you cannot go to SRA. What the civil remedies are, civil remedies like for the possession of a property, possession, enforcement of contracts, those are the civil remedies, because it is affecting you as a person. It is not, because under penal remedies it is against the world, as you must have studied in your basic IPC section, IPC criminal law, BNS we have now. It's not basic. So SRA as a civil remedies, what it will provide you, it will be helping you with property transaction, contracts, documents, to declare something or to provide injunction. I hope you were able to understand even 50% of what I told. If you were able to understand 50% as well, then it's all very good. You should congratulate yourself, because it is a very complex legislation which I can understand as my experience from whoever I taught, and also the understanding the complexity of this legislation. I really appreciate for you for watching this video till here. Thank you so much for watching. Please like the video, subscribe the channel, and also stay tuned for next videos as well. Thank you so much. Please do comment to me as to what are your views on this. Thank you so much.